Good evening. Welcome to the December 17th City Planning Commission meeting. We'll begin our meeting with a roll call.
Commissioner Woods.
Here.
Commissioner Briggs.
Here.
Commissioner Mills.
Here.
Commissioner Milstein.
Here.
Commissioner Gibb Randall. Commissioner Ackerman. Commissioner Sauvé.
Here.
Commissioner Abrams.
Here.
Commissioner Hammerschmidt.
Here.
We have a quorum.
A lot of alphabetical order. Get us all
Yeah.
There's actually
thinking.
sometime I will share the boring reason why it's in that order.
Do we have any introductions this evening?
We do. I would like to introduce Chris Frost from our city. He's an assistant city attorney in the city attorney's office. Chris has been invaluable in helping us present to you a better draft of the sign ordinance, and he is here to make sure that I don't get you into any trouble.
Thank you and welcome. Approval of the agenda. Do you have a commissioner that will move the agenda? Moved by Commissioner Mills, seconded by Commissioner Sauvé. Commissioner Hammerschmidt.
I need to make a motion to amend the agenda to remove 825 North Maple.
Thank you. That applicant has withdrawn that petition, so I would suggest that we amend the agenda to remove that item from consideration.
Great. Can we consider that friendly? Commissioner Sauvé and Commissioner Mills? All right. All those in favor of the amended agenda, please say aye.
Aye.
Oppose? It is approved. Moving on to minutes of previous meeting. Before us this evening, we have the November 19th and December 3rd minutes for our approval. Do I have a commissioner that will move those two? Moved by Commissioner Abrams, seconded by Commissioner Hammerschmidt. Do we have discussion? Commissioner Briggs.
Yeah, just one small correction. On the December 3rd meeting minutes, it says that I'm absent, but it also has me saying things in the meeting, so I'm
I
pretty
don't
sure
know
I
how
was
you
there.
did that.
Yeah,
Sorry, we'll correct that.
We will get those corrected.
thanks.
Any other changes to the minutes? All right, all those in favor of the corrected minutes, please say aye.
Aye.
Oppose? All right, they are approved. Reports from city administration, city council, planning manager, planning commission officers and committees, written communications and petitions. Our first item is 6A, city council. Commissioner Ackerman is not here, so we will move on to Mr. Leonard for the planning manager report.
Yeah, and a couple items from City Council as well. Last evening at City Council, the City Council tabled a proposed contract to award a contract to Interface Studios as the city's consultant to update the city's future land use plan. They're interested in perhaps a working session to dive into some of the details and potential changes to that proposed contract in more detail. So we'll be looking to respond to that probably in the early next year. Hideaway Lane, which was a development project that was previously recommended for approval by this board, was also approved. It also included just, and this is something that I think that this board has expressed interest in, as well as with some comments about revisiting the planned project modification component of our ordinance and the specific types of benefits that we'd like to see. So that some of those comments that you have addressed in the future were echoed there. So that might be something we want to consider in our work plan. A resolution that directs city staff and ultimately potentially incorporation of the UDC, additional protection for trees, perhaps the identification of heritage trees that would be a category perhaps above landmark trees, and an increased amount of protection for those. So those are some related actions from City Council last night, and nothing from the planning report.
Thank you. Planning commission officers and committees? All right, seeing no one. Written communications and petitions. We do have some written communications, so please take a look at that. Now is time for audience participation. At this time, any members of the audience who wish to address the planning commission regarding an item that is not on the agenda this evening, you will have up to 3 minutes to address the planning commission. So if you are here to address an item that is not on our agenda for this evening, please step up to the podium, state your name and address for the record, and you'll have up to 3 minutes to address the planning commission.
Karen White, 2719 Cranbrook. I know we're going to be moving forward with the master plan replanning effort, but I'm hoping that in a somewhat shorter time frame, we might be able to incorporate ways for citizens to register those elements of their neighborhoods, those natural features that they find particularly significant and important, so that they might be on file for the Planning Commission and the Planning Office to be considered as more developments come forward. I don't want to wait 3 or 4 years for the master plan process to be finished before I'm able to start advising someone in the city who has to listen to me about, gee, this is a very old, very large oak. Gee, this is a very significant grove. I see them all over now, and now I'm paranoid. So I'm hoping that we can put in place some procedures for registering that sort of thing, maybe through the Fix-It app. You know, if I took a picture of every feature that I found significant and could submit it through the app. So that's something I'm hoping you'll consider. Thanks.
Thank you. Is there anyone else in the audience who wishes to address the Planning Commission in regards to an item that is not on the agenda this evening?
Thanks, Chair Milstein and Planning Commission. I'm Ken Garber, 2387 Hilldale. As you know, we are in a climate emergency. Burning natural gas accounts for 27% of the city's emissions, over 500,000 tons CO2 equivalent emissions a year. This gas is burned to heat buildings, and any serious attempt to get to zero emissions must tackle this problem. We need to fully electrify our buildings across the city. We should start with new construction, since it makes no sense to install gas furnaces and boilers with useful lives of 30 years, along with building envelopes designed around a fossil fuel infrastructure, only to rip it all out in 10 years in favor of air or ground source heat pump technology. Just in the last 6 months, 4 California cities, San Jose, Berkeley, San Luis Obispo, and Menlo Park, have passed such ordinances. A month ago, Brookline, Massachusetts did it too. Brookline's law applies both to new construction and to major renovations. Now I know what you're thinking. Michigan's building codes must preempt such a ban. Maybe, but I don't think so. Several of us have looked carefully, and we cannot find any preemptive language. Not in the Michigan Building Code of 2015, and not in the authorizing legislation, the Still DeRossett-Hale Single State Construction Act of 1999. This says, quote, "Except as otherwise provided in this act does not limit or restrict existing powers or authority of governmental subdivisions, and this act shall be enforced by governmental subdivisions in the manner prescribed by local law or ordinance." Missy Stultz has already sent this whole question to the city's attorney's office, but has yet to hear back. I'm told it can take months to get an answer. Maybe Mr. Frost can take a look at this. In the meantime, we should draft an ordinance. The Brookline law is a good starting point. It bans fossil fuel infrastructure in new construction and in significant rehabilitation, which is carefully defined. The law establishes a board of experts to hear and decide waivers and appeals. Developers here should not still be putting in new fossil fuel infrastructure in 2020. We need to stop the bleeding. This is a no-brainer to me. Costs the city nothing, benefits developers in the long run. We can't wait until OSI finalizes its carbon neutrality plan next March. Incidentally, in my opinion, city planning staff should inform all petitioners of the 2030 carbon neutrality target and push fossil fuel-free buildings. We can't require this yet, but let's make it clear that it's our baseline expectation. Maybe Mr. Leonard and his staff are already doing this, but if not, I think you should start immediately. Thanks for considering this and for all your fantastic work.
Thank you. Is there anyone else in the audience who wishes to address the Planning Commission in regards to an item that is not on the agenda? Seeing no one, we'll move on to public hearings scheduled for next business meeting.
We have 3 public hearings scheduled for the next business meeting on January 7th, 2020, if you can believe it. The first is the Standard at Ann Arbor. This is a proposed apartment community with a 10-story structure on the north side and a 5-story structure on the remaining portion of a 1.1-acre site located at 425 South Main Street. It includes 208 dwelling units, ranging from 1 to 4-bedroom apartments, and two units proposed to be affordable, and 6,020 square feet of retail space, and a total of 102 off-street parking spaces. This is you might know this site as the DTE Edison office building on the corner of William and South Main. Then we have two proposed annexations and zoning by property owners. One is at 2511, a proposed 2511 Newport Road, an application to annex a 1.5-acre parcel from Ann Arbor Township and zone it R1A, single-family residential, in order to access utilities. No change is proposed to the current single-family use. And 2731 Newport, annexation and zoning, an application to annex a 1.3-acre parcel between White Oak and North Maple from Ann Arbor Township and zone it R1A, single-family residential, again, to access utilities, and no change of use is proposed.
This will be a very exciting start to our year, come January 7th. All right, unfinished business is next up, and the first item there is sign ordinance amendments for city council approval. And we'll begin with Mr. Leonard.
Yeah, we don't have a PowerPoint presentation because of the text orientation of this, but for members of the audience, if you didn't grab it, we have plenty of copies of the proposed staff report and draft ordinance there. I just want to set the stage, and then I'm going to turn it over to Chris Chang for a brief overview of some of the changes from the last time you saw this ordinance. But just to frame a couple of reminders, in 2015, through the case of Reed versus the town of Gilbert, the United States Supreme Court determined that content-based signage regulations are presumed to be unconstitutional. This decision is based on First Amendment precedent of the Constitution, which prevents governments from controlling or restricting speech based on its content. So the city has undertaken the process to revise the sign ordinance, our sign ordinance, as our existing ordinance is decades old. It has been amended numerous times and likely includes provisions that would not meet this new precedent of the Supreme Court and the test of Reed versus the town of Gilbert. So the city has worked with a consultant to develop the majority of the draft ordinance. Since you've last seen it, staff has taken that time to make some additional adjustments and incorporate the proposed language of that draft into our UDC format, more consistency, including consistency with existing definitions, heading structure, and the like. There are also some changes that we're going to summarize, and based on the combination of those changes, it is my assertion that this ordinance needs to come back to the Planning Commission for reconsideration based on the level of changes. The proposed ordinance that we continue to present to you, we believe that will now meet the legal precedent set by the Supreme Court utilizing a content-neutral approach. We do this generally by identifying overall requirements that apply to all signs, then regulating by the size and type of signs by zoning district and or use. Specifically, we regulate the signage by the D1, D2, and C1AR, or what we are envisioning to be sort of our core downtown districts. By other mixed-use, non-residential, and special purpose districts. This would be inclusive of districts like the remaining commercial, industrial, office, and the like. And then by residential districts based on the number of residential units and or the non-residential use status in those districts. That might be a school or a church or another use in a non-residential use in a residential zoning district. The ordinance also attends to address content neutrality and provide an accommodation and limits on temporary signs to provide what we believe is an adequacy of free speech opportunities for all property owners in the city. So that is the framing of sort of how we got to where we are, why it's coming back to you. I'm going to turn it over to Chris to provide an overview of some of those changes, and then we can address any questions that you have either before or after the public hearing.
All right. Thank you, Mr. Leonard. As he had just mentioned, that we are moving toward regulation by zoning district in a content-neutral manner. This reflects current best practices in response to evolving court decisions and sign regulations. Some of the amendments are more significant, and that's why we're back here at Planning Commission. And they are, as listed in the staff report, as the following. Sign area calculation and height is formatted and clarified in code and separated from the table of sign types, eliminating marquee signs. Existing marquee signs are now non-conforming, and new reviews would fall under awning requirements. We're eliminating 3-square-foot wall signs in the 1 and 2 family residential districts, reducing the maximum size of wall signs for 3 family units and greater from 12 square feet down to 6 square feet, and listing exceptions for signs requiring a sign permit under section 5.29.2 sign permits, which is listed in code. Some other things that came up during our review are questions and comparisons for the UDC sign ordinance amendments, which are proposed for outdoor lighting regulations and by our Environmental and Planning Commission. And the 2 sets of amendments comparing the sign code and the lighting code are light trespass. Both the sign ordinance and outdoor lighting ordinance identify a limit of 0.1 foot candle for light trespass near residential property. The sign ordinance restricts by residentially zoned property, and the outdoor lighting proposal restricts by residentially used property. We can go into that further if you have questions. The sign ordinance does not limit to non-residentially zoned properties. The proposed outdoor lighting ordinance sets a 0.2 foot candle limit in such circumstances. Full cutoff fixtures are required under the sign ordinance and the proposed outdoor lighting ordinance. The sign ordinance limits the electronic signs to 5,000 nits during the daytime and 100 nits at night, so we're using the nits as a measuring unit. Both the sign ordinance and the proposed outdoor lighting ordinance limit illumination while property activities are closed. A revision suggested at the last Planning Commission review included limiting illumination based on when the business that the sign advertised was closed. This has been revised to a slightly broader content-neutral approach that looks at whether all businesses on the lot are now closed. And city staff have not historically received complaints from light trespass from non-residentially zoned or used properties. So staff anticipates the proposed lighting ordinance to address this issue, or the sign ordinance can be amended in the future. What you have also in the staff report is a chart that's what's listing out by zoning district, and that's a big change from what was previously done. But what the current sign code is and what the proposed sign code will now, what we're proposing, if approved. I'm not going to go through the whole chart, but I'm happy to go through it if you have questions during our meeting. And I'm open to any questions you may have.
Thank you. At this time, I'd like to open up the public hearing on this item. Members of the audience can address the Planning Commission for up to 3 minutes. Please come up to the podium, state your name and address for the record, and you will have 3 minutes to address the Planning Commission.
Hi, I'm Sally Uwe. Address is 922 Pauline Boulevard. Professor of astronomy and also leader of the Michigan Dark Skies Community Organization. I just wanted to say that a couple members from our group are here, and we are very excited because this is going to be one of the first big steps for controlling light pollution in our community. Really want to thank Commissioners Mills and Commissioner Briggs for their help with this. And just hearing what we have what you've just described on the differences between the sign ordinance and the lighting ordinance, that one of them was based on limiting light trespass based on residentially zoned property versus residentially used property. It might be desirable for you to think about making those two things consistent. That was the first thing, the first time that I actually had taken note of that. So thank you for pointing that out. So thank you very much.
Thank you.
Good evening. My name is Jeff Rechton, R-E-C-H-T-E-N, from 10904 Braun. And just wanted to, as a member of the Michigan Dark Skies, wanted to address the commission and thank them for their support of dark sky initiatives.
Thank you.
Hi, Karen White, 2719 Cranbrook. I'm here in 2 capacities as a supporter of the Dark Skies Initiative because I've been working at the Detroit Observatory for a number of years now, and I know what it's like to try to observe the skies in our community at night using telescopes. So you don't even have to be an astronomer to know that there's too much light pollution. And in my second capacity, as just a private citizen, I would love to be able to share with my family some of the things that should be able to be seen in the dark sky and currently are not when you're in Ann Arbor and you have to go quite a ways out of town. So I encourage you and applaud you for taking this on, and I please hope you will torque down ever more. Thank you so much.
Thank you.
Good evening. Jeff Crockett, live at 506 East Kingsley, and I'm pleased to be here. I just want to briefly say, because we've been involved in monitoring, planning, and development for quite a while, we think that the efforts made for community outreach, particularly Brett and his staff and Chris, have been a significant improvement. So we're really pleased about that. I sent you an email that sort of outlines a series of questions and some recommendations. But I'm not going to go through all that. I just want to basically say that the primary concern here is one of process. And I want you to understand what it takes. This is a complicated document when it gets down to the details of signs in regards to residential neighborhoods. And basically, our process, first of all, we live in a historic district, and we're very tuned to signs. In fact, we probably report more sign violations than many other people, including one just recently. So we're very sensitive to this, but we're also very supportive of the statement that you make in terms of the avoidance of nuisance-like conditions. It says the city finds that due to the concentration of people and activities within the city, there is a potential for blight, physical clutter, excess light and noise, and visual clutter, and we totally agree with that. The problem is we've been involved in trying to get input this for several years when the sign ordinance revision first started, and we've been in contact with Chris quite frequently. So the last iteration of this was August the 1st before this. So we were in contact with Chris to try to find out when this hearing was going to take place, and we found out maybe 2 weeks ago it was going to be tonight. So we convened our board last Wednesday night to go over what was then the most current one, and that was the August sign ordinance. And we came up, and that was the basis for that letter. But then we found out that the latest iteration wasn't going to be available till Friday afternoon. In fact, we found out at about 4:30 what the latest one was, and so we scrambled over the weekend to try to read and understand, and that was the basis for that letter. Just keep in mind that, in our opinion, there should be far more time for neighborhood groups in particular to sort of understand a complicated ordinance like this. It's not just you read it and we respond. We have to read it, we have to meet, we have to think, and then respond. So we're hoping that this process can change in the future. There are a number of other concerns that I have mentioned, and I guess the most important of which is temporary sign ordinance, which we feel is basically unenforceable the way it's structured. But my time is nearly up, and my wife, Chris, will sort of take over from here. Thank you.
Thank you.
Hi, I'm Chris Crockett. I'm president of the Old Fourth Ward Association. If there's a neighborhood that's impacted by temporary signs, it's ours. We are the neighborhood just north of campus, and we have sign pollution. There are some landlords that are particularly egregious about their use of signs. There's one in particular who routinely has as many as 8 to 10 signs, supposedly temporary signs, except they're there all the time. She already has signs posted for fall rentals for next year. This is just unacceptable. And to put the burden on the neighbors who care about the neighborhood, those of us who have lived there for decades, to constantly report it, that is also unacceptable. We really need something in this ordinance to deal with the sign pollution. It's not enough just to limit the size of permanent signs and then allow landlords to have anywhere from 8 to 10 temporary signs posted all over their unkempt lawns, because they never take care of the lawns. Not a blade of grass is planted, not a flower, not a shrub, nothing. It is just sign pollution. And I can tell you privately who some of those offenders are. But we have dealt with banner signs that are illegal and lots of signs that have been permanent. We've gotten them taken down. We've been doing this for the whole time we've lived in the neighborhood. And we really would like some relief from this burden. And we hope that you can do this by giving this sign ordinance some real teeth. Our neighborhood is probably more affected than any other residential area because we are so close to campus and it's mostly rental. And the landlords want to make money, and so they probably think if they put 8 to 10 signs on their front lawn, they're going to make money. But to have signs at this time of the year advertising availability of apartments for the fall of 2020 is just outlandish. It's not necessary. So we really need your assistance to address this problem along with others. We want you to really take a hard look at this grandfathering because already some of the signs that are posted are pretty awful. There's one new manager in town that has a permanent sign on the house and then another huge sign strung up between the pillars of the porch. Totally unnecessary. Anymore, if students can get, or any renter get the contact information, they contact landlords online. So, thank you, and thanks for all your work.
Thank you. Is there anyone else in the audience who wishes to address the Planning Commission in regards to this item? Seeing no one, I will close the public hearing and read the motion. The Ann Arbor City Planning Commission hereby recommends that the mayor and city council approve amendments to Chapter 55 Unified Development Code, Section 5.24. Moved by Commissioner Mills, seconded by Commissioner Woods. We are in discussion.
While you're getting started with your comments, I'd like to propose a couple of amendments actually to the draft you have. I think they're fairly minor, and as usual, I apologize. I'm noticing I don't have page numbers here for you. The first amendment is under temporary signs. So if you go to section 5.24.7, temporary signs, then sub A sub 3. It's the title on the top of that page is temporary freestanding signs. Under the exceptions B, there's a reference in the final line of unlimited sign that the requirements sign is subject to the placement requirements and counts toward the maximum sign area for freestanding signs provided in table 5.24.4-4. That should be 5.24-5. That was we had added another table in this draft and failed to update that reference, so I propose that change for the version you consider. And then additionally, when you go to section 3 of the proposed, or section 2 of the proposed UDC ordinance, which is where you get into the sign permit section, the title of that page says section 2, that section of 5.29.2. It includes a sign permit sub C, display of street address. This is language that originally we held over from our current code, and essentially it's a check that you couldn't be eligible for a sign permit at a property unless you had adequately displayed the actual address of the property for wayfinding and public safety. However, independently of the zoning ordinance, Chapter 2 of our city code requires that of all properties that an address be provided. So I think it's duplicative to include it here in the UDC, and I would suggest striking item C.
Would those be friendly amendments, Commissioner Mills and Woods?
Yes.
All right, very good. All right, we are in discussion. Commissioner Mills.
Leave it to the person without much of a voice to start, so I'll be short. The first thing is about the lighting. Effectively, I want to have a little bit of a discussion. I appreciate you doing that comparison, and I agree that there's a lot of places where they match. You note that the lighting ordinance, so the lighting ordinance, or I'm sorry, the sign ordinance now is based on district rather than use. So it doesn't make a difference how the building is used in a particular district. We allow residential properties in many of our districts. It's assigned to the district, is that right?
Correct.
So in that way, in moving towards a light trespass threshold that is based on a district, there's likely going to be, that's less restrictive generally. Like, there's going to be a little bit more trespass, because there are a whole lot of properties of residentially used properties in non-residential districts. Is that a fair assertion?
Yeah, as it's drafted now, the most protective trespass provision would be where you have residentially zoned property, with the presumption that that is always going to be residentially used, except for very in few circumstances. It doesn't afford the same protection to a residentially used property in a non-residential zone. Similarly, that property could be used for a lot of different uses other than residential as well. And so you're right that it is impacting residential uses potentially differently. If there's a rationale for it, is that a residential use within a commercial or mixed-use district is of a different character than a district that might only restrict to residential uses solely.
Generally speaking, within the UDC, the Unified Development Code, that's our zoning ordinance, how common is it to set standards based on use? Like, for example, the screening, like the vegetative buffers, that kind of thing that we have, how much of it is based on the use versus the district that it's in?
I'd have to spend some time sort of inventorying those provisions. I think we have instances of both, but I don't know if one is more prevalent than others.
Got it. From my perspective, for the purposes of this, because this entire ordinance is based on a district, I don't necessarily want to change that on the fly. But I think that this is something that we might want to have a conversation about when the lighting ordinance comes before us. Again, in what I just heard was that there would be less cross property light pollution if we set that trespass based on the use of the property rather than the kind of district in which it's in. Again, because of this ordinance, the sign ordinance that's before us tonight, everything is set up based on the district. I think that makes sense for tonight. But I might want to revisit that in the future. I want to put that
Do you have any
idea out
initial,
there.
do you have any initial thoughts how you would consider a mixed-use property? Like, say you had a retail space with residential above?
I think if it's on the very same property, like then that counts as that's a good question. And I think this is something that we talked about a little, and so
Yeah.
this is why when that comes back, I think we should
Yeah. So I think,
talk about that.
I think that might be a rationale to keep it as a zoning district designation, but that would be the kind of question we'd want to understand.
Okay. I'll let more people who have more of a voice talk about that a little bit more. I just wanted to get it out there. And the other thing that I wanted to ask some questions on, and I appreciate the kind of comparison. There is, if I'm reading this correctly, there is a substantive change from August until now in that in those 1 and 2 family residential districts, we're actually reducing the amount of signage overall that's allowed. Is that correct?
Yeah, a change from the, sort of the evolution of that change from the current sign ordinance, we have a provision that allows a sign on such properties restricted to the address and the names of the occupants. That is obviously a very content-specific regulation. Our initial draft that we presented to you earlier this year carried forward that opportunity to maintain a sign on those properties. Talking from a staff perspective and sort of the character of such uses, we now are recommending that, sort of approaching that from a different lens, we provide addresses and in fact require addressing for properties that accommodates similarly what was previously provided, and now are reducing, as you said, what was previously provided as up to a 3 square foot permanent sign. Now we're not proposing any such provision of permanent signs for single and 2-family residential.
Got it. But there is that page, the first edit that you had us make. We are allowing for a temporary sign that's for unlimited amount of time, which, can you help explain to the average person how that is different than a permanent sign? And by saying that it's freestanding, the way that I'm reading this now is that we know that in the Old Fourth Ward and in other areas around campus where there are single-family homes that are rented out, right? Or duplexes that are rented out, it's very common to have a sign, a wall-mounted sign that is permanent by, we would all see them as permanent on the house. Is this saying now that they can do that, but it has to be freestanding? And is that better?
Yeah, it would have to be a freestanding sign to invoke that unlimited duration potential.
Got it. So all of those, so long as the districts that we're talking about are R1 and R2 districts.
Or single or 2-family uses in residential districts.
Or single or 2-family uses in an R3 district, R4 district, then they would not be allowed to have a sign on their building,
A permanent wall sign.
a
that's
permanent
correct.
wall sign on their building.
Correct.
They could have a temporary one that could
Correct.
be up for 2 months and then taken down for 30 days and put back up for 2 months.
Correct.
Got it. And can you talk through, 1, the enforcement of that, and 2, what's the rationale for allowing, also again, the definition of a unlimited temporary freestanding sign?
So enforcement for sure will be challenging. Although right now we have a lot of provisions for temporary signages on a content specific that are equally difficult to enforce. Like anything, we tend to be complaint driven. I forwarded responses to that we had received a question about that. I don't profess that this is easy or automatic. We would have to ultimately document that something is exceeding that duration of enforcement. And remind me again of your second question.
The rationale behind having something that's identified as a temporary sign with an unlimited duration.
Oh, yeah. Particularly by restricting single-family properties and duplex properties from having a permanent sign, with any content neutrality, keep in mind we are trying to find a physical regulation based on a geography or zones. We no longer are distinguishing that a real estate sign is regulated different from a political sign. And we think that a balance of free speech available to all property owners is important. And we think that this is a relatively unobtrusive way to accommodate that. If you, for example, say you had a sign that says, "This house supports immigrants and refugees," that we are providing some opportunity for you as in this case, a single-family property owner to have at least a small portion of unlimited display of some message that we are somewhat oblivious to as to what its content is. And that's in a temporary fashion, which means it can't be lit. It has to be under the certain size and other restrictions.
Got it, thanks. And there's one more question, because I did read some of the letters that came in, and the one was about the signs, it effectively entrances into subdivisions, where it says you're entering whatever estates or whatever. So would this then, how does this apply to those subdivisions?
Yeah, right now, we provide an additional sign for multifamily when it is over 5 units, I believe. I'm looking for acknowledgement of a permanent sign. So for large residential developments, you would get a additional 50 square foot freestanding sign. So we are limiting such occurrence to a multifamily, only to large multifamily. For a single family development such as that, would likely not meet that test, would not be eligible for a monument sign.
I'm okay with that, but I just want to make sure that we know that now that would be a change, that, and again, the signs out there for the single-family developments, I can't think of one, but I can only think of from my hometown, because you don't see them downtown, right? It's more on the periphery, kind of the suburban design. Those are not, those would be non-conforming, and they're okay until,
They would be subject to all the non-conforming requirements of
Right.
maintenance. If they were ever wholly removed, they could not be reestablished.
got it, thank you, and, got it.
Commissioner Sauvé?
I'll start with some clarifying. The question, like billboards, marquee, grandfathered in signs as it relates to regulating content. So it says that billboards are no longer allowed, but, right? And so, but those are changing. So if I look at the proposed sign ordinance, on and off premises signs no longer regulated separately. Previously approved billboards may remain, no new billboards, signs of over 200 square feet. So in context like that, the content is still changing, allowed on that physical billboard.
Yes.
So is that the same for marquee signs and other sorts of signs, that the content within the physical sign area may be changed? Like, where's that line of modification of a grandfathered sign?
Yeah, in the marquees, certainly we have the marquees that we have do have existing changeable copy. The changeable copy of those would continue to be able to be changed. I just want to go to the non-conforming
I'm thinking of,
provisions
like,
to see if
hand-
something more
yeah.
substantial,
Yeah.
like if you had to,
If there's like a hand-painted antique marquee, you could paint a new name on it or a new message on it.
can you think of a hand-painted marquee that we have?
The beer, is the base of Westgate?
McKinley? The McKinley marquee?
Yeah, that one would be one.
Where?
The McKinley building?
Canopy?
Main?
Well, to be clear, awning and canopy signs are still allowed. So you could totally redo an awning or canopy sign. We're thinking more
about-
about the marquees, like you got the Michigan
Like
Theater, the
Westgate?
State Theater. Like, we used to define those differently. When you compare them to our actual awning and canopy, they are signs on a projection from the building.
So what would be the beer drive-through, or the Westgate, or the Arborland, or Morgan and York?
They'd be, Morgan and York would be a freestanding sign.
Okay.
Beer Depot would be a freestanding
Depot.
sign.
And how are those changes for,
So those would be those are
Okay.
non-conforming signs. If they can be maintained, but if they were to be reconstructed, they would have to meet the requirements of size, setback from the property line, depending on their height.
I guess it goes like because the billboard we know is a changeable sign versus another kind of non-conforming sign that you might change the content of. So I guess that's the question of, knowing the type of sign for changeability and grandfathered in, and how that's regulated or looked at.
So so I want to understand the question. So the
like-
distinction between being able to change the content of a non-conforming billboard versus if Morgan and York became Lisa's
Yes,
Beer Emporium.
yes.
Okay. Okay.
Sounds
So,
fun.
Shall be maintained and repaired in the same form and type. Can't change it to another non-conforming sign. Shall have any change made in the sign structure. You can't make any change to the shape, type, design, or mechanical equipment. Shall be any change that result in a different type of greater illumination. I think
it's there on 5.29.2B. No permit is required for changing the changeable copy of a sign unless the changeable copy is being replaced with a permanent sign.
Yeah, I guess that's a question I want to go through a couple scenarios, like of
Yeah.
those examples to make sure it works, but in short, I do think that you could replace the sign. However, if you were to change the shape or increase the
illumination
size
or-
or make it brighter, then you would likely not be allowed to do that.
Right. It just seemed like billboards were a very obvious thing that they're now restricted, but the ones that exist are completely changeable.
Yeah, but I think you're also, no, I
Right.
think that's true. And we could work on some clarity to make sure that that is clear. I'm also trying to reconcile some of the particular examples you're talking about. I know also might have had variances in the past. I'm also thinking recently, for example, Arborland wanted to change,
Right.
and that also required a variance because it didn't meet this exception.
Right.
Those, to be clear, we have that appeal process built in if somebody can't meet this in any circumstance. But I understand what you're saying, and I guess I'd want to, I could spend some more time with some scenarios just, and maybe bring you back some examples of how it would apply in some of those circumstances as sort of cases.
Yeah, I guess that was just because billboards seemed like a very obvious changeable copy in a grandfathered in condition, where that might play out in other types of signage and the grandfathering in clause. Because it seems obvious in the billboard, but then I don't know how it trickles through everything else, so that was kind of
Yeah.
something that I think would help. I think on light trespass, like, generally, my position of the sign ordinance here now is that this is making progress, and that the progress will need to be, tweaked and amended in the future as well, but working from a content-regulated sign ordinance to something that is content neutral for things like the residential zone versus residential use. I say we start at zone, and as we see conditions, and maybe it's the same with this content, of billboards versus something else, that we start to move the needle by setting kind of a new format generally. So I appreciate this coming back and trying to clean it up and get clarity generally. Thank you.
Commissioner Briggs.
Yeah, just to follow up on the lighting issue with zones rather than uses. I think it's perhaps, still appropriate for us to be using the zones in relationship to the signs, but certainly with outdoor lighting proposal, I would hope that we could continue with the residential use there. I think that it is more pertinent in that case to have us thinking about uses, especially as we are moving our city in general, thinking about having more mixed-use properties across the city. And I think it's important to be thinking about light trespass everywhere that people live, not just in residential zones. So on that, in terms of some of the questions that got brought up in terms of the Old Fourth Ward. Chris, do you mind, I know that there were some answers that came out to us. I don't know how much those were conveyed in advance to Old Fourth Ward, or if that's useful to go through those answers publicly right now.
I don't have a copy of the
Okay,
responses,
yeah.
but I do know that we had crafted them and sent them out kind of later today, so, to the public. But if you've got them, I don't mind if they're shared publicly, Mr. Leonard.
yeah,
But I don't have a copy.
Okay, got it.
I can summarize that this afternoon, the responses were provided to them, and shortly after I forwarded those same responses to all of the commissioners.
Okay.
So everybody should be, I think, I know the Crockett's were on that email, and several other people as well.
Great. And in terms of, after this passes tonight, I should say, if this passes tonight, what would be the next steps in terms of when it would be going to council, and what's that timeline look like?
Yeah, probably the earliest it would progress to council would be first reading at the second January meeting of city council, or the first February meeting. So that'd be my estimate, one of those two meetings for first reading, then it would require a month delay before the second reading and public hearing.
Okay.
So I would guess final consideration and a public hearing at city council, if recommended for approval this evening, would be either the second meeting in February or the first meeting in March.
Great. In terms of the concerns that sort of were raised this evening in terms of process, and I am sympathetic because I spend my day job reviewing sign ordinances and lighting ordinances and things like that, and I know it is very tedious and also very challenging to just have a couple of days to be able to kind of go over those and review them and understand what those substantive changes might look like. I think staff did a great job in terms of identifying what those substantive changes look like, and also looking at the direction that those changes are headed. I think that they're more restrictive rather than more permissive, which I think is beneficial to the community. And I'm reassured to some degree that there's going to be a good chunk of time, especially over the holidays, and a good month to be able to review this more before first reading. If anything really substantive should pop out, I think that we have a pretty receptive council to listening to concerns that get raised. So hopefully nothing gets observed in that time period, but I think there is still opportunity for changes if something odd gets noticed in that time period. In terms of enforcement and how those, has anything changed in terms of the ability for the city to enforce, or fines in terms of the update for the sign ordinance?
I don't believe there are any changes to the amount of the fines. As far as enforcement, which was already mentioned, it is challenging. We do have somebody on staff that does go out and respond, hopefully in a timely fashion, to make corrections before we do issue a ticket. But it's probably going to be, as previously stated, complaint-driven. Once we receive complaints, that's where we really can start our follow-up.
Oh, and what was the rationale in terms of eliminating marquee signs?
Well, as was previously discussed, there's not a whole lot of marquee signs out there. If there were any changes that were needed, you could always go back to the Zoning Board of Appeals, and we still have the effect with canopy and awning signs for someone to come out and get an approval for signs of that nature.
Okay, sorry if I missed that explanation earlier. Okay, thanks.
Commissioner Abrams.
Maybe I wanted to begin with a couple clarification questions. Like I noticed in the list of prohibited signs, 5.24.3C includes exterior pennants, and I'm wondering if that includes flags, whether those are athletic or other related holiday, and maybe also I'm wondering where things like holiday decorations fall in any of this.
The pennants that we would typically interpret that to be are sign pennants. Oftentimes, we see them on commercial businesses. They tend to be strung maybe along property lines or between buildings. There would be, however, it is conceivable that some temporary sign, wall sign, could be in the form of a pennant, but our intention is sort of those that are strung.
So not a flag that's
Well-
braced by a pole, has an M on it, or a S, or a rainbow, or a,
Flags.
If I may, the pennants are also defined in the definitions.
they are, I'm sorry, I apologize, I didn't see that. Triangular or irregular, so not rectangular.
That's
Yeah.
irregular.
Yeah, I think that was an intention to, we have had, again, have some issues like where they're just sort of strung to draw attention to a property. Less intended to define as a single temporary sign, but more of linear. Flags is an excellent question. Previously, we had provided flags as an exception. I think now they would be incorporated.
Oh, my definitions are missing D, E, F, G, and H, so I
Because we made no changes to those letters.
So flags may be in there, maybe defined in there.
So flag poles are clearly allowed in all zoning districts. My initial reaction is that because we clearly allow those as a structure in zoning districts on any property, that I think it would be a logical interpretation that we wouldn't require you to put a flagpole up without the flag. So I think that's,
Flags are okay.
yeah.
And maybe returning to pennants for a moment, though, like a resident could not hang like one strand of Tibetan prayer flags or something on their porch, or
If it didn't meet the temporary
if
sign
somebody
definition, then
complained.
no.
Okay. And then my next question relates to Figure 24A, calculating the sign area of freestanding signs. The last example given shows a non-illuminated sign. And I wondered what the rationale was behind how the sign area is measured. Where in, one could see a version of this where the actual sign structure is much larger than what's illustrated here, but the sign area would still be small.
Yeah, so the intention there is that if it's not illuminated, essentially, we'd be providing sort of potentially more sign area for that definition. However, if you go to the example above and it was backlit, for example, in a light box, we would be counting the whole. In circumstances where the structure on which elsewhere in the code, in circumstances where that structure holding the sign is more than 3 times the area of the sign, then we would then proceed to count the full size of that structure towards the sign definition. So it's a sort of, in short, sort of a small incentive, if you will, to not illuminate your sign
That allows you to have a larger sign
if you don't light
up
it.
to a certain
Yep.
proportion. Okay. And then I had a clarification question about window signs, and which are described in 5.24.6. I wondered about like perforated vinyl window cling, which can in theory cover, cover an entire window. I guess I just wondered whether that counts as a sign, like a graphic, because I also noticed in here that, like window, things on display, goods on display don't count.
Correct.
I know I'm getting nitpicky here, but I think there's a lot of nuance, and I think there are, like real estate agents who fill the window with signage of properties that I have for sale or for rent, and would that be considered goods goods on display, or a window sign, a sign in a window?
So that could be considered signage. We would certainly look at any circumstance and make that determination. As it relates to your question about window film, this is something that we encounter quite a bit. For example, one of the things that we debated in putting together this language was, would we restrict wall signage to no more than 25% per window? That is, you would never be allowed to fill up more than 25% of any individual window. We opted for this approach, which would potentially allow you to consolidate the area. If you had 4 windows, you could cover one window with graphics. This does not prohibit you from potentially blacking out windows with a vinyl film, so long as it's not signage. And you will see that circumstance in the city in some cases. Sometimes it can be challenging to, if it's just like a solid color, that's one thing. Sometimes in the past, we've had to make judgments about whether that is, such product is acting more as, includes some graphic, and whether it's acting as signage or art. And frankly, it's, those are some of the challenging interpretations that we occasionally have to make. But to be clear, this wouldn't prohibit sort of blacking out a window. It would restrict more than 25% of that window area from being filled with signage.
Okay. That's it for now. Thank you.
Commissioner Hammerschmidt.
Following up on that, just for clarification too, are we talking about just the front of buildings, or is this any, like, I guess I'm thinking now about like purely residential, but, you know, can you hang pennants in your backyard?
So this is the window area is calculated by ground floor business frontage. We did discuss whether or not to specifically provide regulations around residential windows, and opted not. We don't have those kind of restrictions in place so we're not proposing to invoke any additional restrictions now. Again, I would put that in an interpretive challenge. It's conceivable that you could put up a Budweiser flag in your window at some point. We would have to make a determination in that case, but we are not specifically regulating residential window signage.
Okay, and then
I'd also like to just chime in. Also, we're only going to regulate signs that are visible from the public right-of-way or from public grounds.
Okay, great. And then I think now I'm thinking about the old Fourth Ward more, and I'm thinking specifically about, you know, these temporary freestanding unlimited signs. So landlords or building property managers who have signs on their buildings, that will be non-conforming, right?
If it is a 1 or 2 family,
Yeah.
or if it is
Right.
a 3 or more unit and it's over 6 square feet.
Okay, so let's pretend these are all like single 1 or 2 family houses. Those can't be there anymore if they want to take them down, but they could, if they, you know, if it needed to come down for some reason, they're not allowed to put it back up, they could have one temporary freestanding sign, or is that a commercial message if it's like a management company sign? I'm just trying to think, like,
Yep.
is it worse to have these like temporary freestanding signs in the yards of these houses than it is to have like the little phone number?
So we're not regulating the content of
Right.
that freestanding sign, and that's intentional to provide the flexibility. Yes, it might be utilized by a property owner to say for lease. Similarly, it might be used by a tenant to advocate a position or a political ideology, or
Yeah.
advocate for a planet or some other message. So yes, they could use that for that purpose. We are not specifying the content. We're trying to find that balance of an adequacy of free speech and physical constraint of the property.
Yeah, no, I completely get it. I just don't want to see like a bunch of temporary freestanding management company signs in people's yards. But I guess I don't know what to do about that.
yeah, that is the balance that
Right.
I hope that we've found with this ordinance, is trying to find the balance of an adequacy of opportunity for people to invoke their speech in a defined fashion based on these geographies. And it is a balance.
So whenever this passes, right now, the current ordinance as it stands is like basically unconstitutional.
Well, I would not clearly state that, but it is not content neutral. You will find lots of references to specific types of sign and specific regulations to those.
Is the amendment process, like if we pass this as is, and it passes as is, but then stuff is found, because you mentioned the old ordinance has been amended several times, is that amendment process painful?
It's the same process as adoption.
Okay.
And one thing that we are also making sure to include in this is while we do have a severability clause in the whole UDC, which is sort of a attorney term of saying that if one provision of this is deemed to be illegal, it doesn't invalidate the balance of our ordinance. So we've added that provision specifically to this. I know we're in 2019, but 2015 case law from the Supreme Court is actually still relatively recent.
Yeah.
And other case law could continue to develop. But in short, it would be the same process. However, I think generally it would be easier because we've started from this content neutral structure where I think the changes would probably be perhaps numeric or quantitative as opposed to sort of starting over like we are now.
Okay. I feel like an imperfect content neutral ordinance is probably better than what we have.
Yeah. Just while we're talking about this, I want to make it clear, this would have the effect of repealing the entire sign section of our current chapter UDC. So I didn't show you that sort of all deleted, but this would replace that provision. And then we did show you the sort of track changes version of the other sections of the UDC that would be impacted.
Commissioner Woods.
I just wanted to follow up a little bit more on the Crockett's and some of their concerns. And so I wanted to just make sure I'm understanding. So currently, with the ordinance that we currently have, what, and either Mr. Chang or Mr. Leonard could answer this, please. What is considered an infraction right now based upon the description that the Crockett's gave us in terms of seeing numerous signs on rental properties in the old Fourth Ward?
It's a little difficult without knowing. We'd have to look through the ordinance to find out what is the zoning, what's the size of the sign, where is it located. So we can't, again, we take them on a case-by-case basis.
Okay. And,
But
go ahead.
just to be clear, like one example that was brought up is if you had 8 temporary signs, this new code would restrict no more than 4 temporary signs in some of those circumstances.
Okay.
So that'd be one example of how that change would occur. I would also say that the sort of non-conforming likelihood of maintenance of a temporary sign versus a permanent sign is probably also different. So there's probably more opportunities to get those kind of properties into compliance long-term than perhaps a property that has a permanent sign affixed to it that's non-conforming.
Okay. And those 8 signs would, if this were to pass, those would be content neutral, which meant that it could be 8 signs for, I don't know, vote for so-and-so or things like that?
Most
Or
likely-
7 voting and maybe 1 that says house for rent? or
Well, again, we'd be restricting it likely to no more than 4 freestanding signs.
4, okay.
They would have to, they could do one of potentially their full square footage allotment, or they could divide that square footage allotment amongst 4 freestanding signs. And you're absolutely right, they could be Save the Whales, vote for Mayor Woods,
I like that one.
and city planner Leonard is an idiot. I mean,
I don't like that.
yeah. So you're right. They are content neutral. We're restricting the size based on the property, and they have some flexibility on how they use that size, but limits exist.
Okay. And then I was also, I jotted some notes down, in terms of a remedy for those who might be neighbors to some of these property owners. Their remedy seems to be that they should get in touch with our community services, do they call it in?
Well, if it's the public right-of-way, they would go to community standards, but anything on
Community
private
standards.
property, they could call the planning, or in this case, zoning. And we have a gentleman that we go out and do enforcement.
Okay. And, I don't necessarily want to say how successful is that, but I'm getting the sense that this is an ongoing issue for some folks who live in the Fourth Ward, because this isn't the first time that we've heard it, or if we drive through that area, you can see some of this too, and not just to the Fourth Ward, but also some other places in town. So, as a staff, are you feeling fairly confident that this would be a good remedy for those neighborhoods that are experiencing this kind of phenomena?
This will not solve all those issues. Particularly with temporary signage enforcement, I think will continue to be challenging. One thing that I think will help address the condition in a more positive way is that we will be standardizing what the regulations are in a way. Right now, our current ordinance has different limitations depending on the size of signage. I think I don't think the sort of consolidating everything into the same requirements is an automatic solution. However, I think it will add a consistency in our ability to respond, frankly, just more quickly than maybe spending the time to research a particular sign content.
Okay. And this may be something that we'll talk about later on, depending on what happens with it here and then on to City Council, but how does the public or the neighborhoods find out about these changes and then be able to realize that it's now standardized, which, as you said, should really make it easier for people to know when someone's in violation?
Yeah, this is a good question. I think unlike probably this more so than other UDC changes might warrant some sort of communication effort that we could look at as we progress to City Council and talk about how we might, any ideas we have on to achieve that.
Thank you.
Commissioner Briggs.
Yeah, so I've been kind of pondering the unlimited temporary sign for a bit, and I feel a little bit guilty because this isn't a substantive change. I mean, this was in there in the last draft, and I obviously didn't, it wasn't?
Oh, no.
Okay. I was like-
It's still okay to bring it up. That's
Okay.
fine.
But to me, this just suggests, this just contributes to sign blight. We're providing folks with 4 temporary signs that can be placed for 65 continuous days. Yes, they need to take them down for 30 days for a gap, but we're providing pretty ample opportunity for free speech and a variety of different mechanisms with 4 temporary signs. And so I'm inclined to think that there's really no reason for us to be providing one unlimited sign on these properties. We already have an exception if the building's up for obviously for sale or lease. And this is freestanding, which also means it's much more visible in our landscapes, which are already quite cluttered sometimes. So I don't know. I would be inclined to put forward an amendment to strike B from Section 2 in the temporary freestanding signs, but I'd like to see if there's any agreement around the table before I put that forward, as others have been pondering this.
So if we can get back to that in a minute, I have a couple of things that I'd like to bring up. Mr. Frost, thank you for being here. I have a question that, we've been slowly moving through through this change in our sign ordinance. Does our current sign ordinance open us up to litigation, the way it's set forth right now? I was thinking Mr. Frost would answer that since he's here, and we'd like to put him on stage.
He might ask me to answer that.
Yeah, that's not, I'm not going to comment on what risks the city might have in public session, but if you'd like more information on that, I could provide some advice separately.
All right. Well, thank you. At least we got you to speak once, so I appreciate that. Mr. Leonard?
I would just say that I believe this draft does put us in a more defensible position, just again, based on the premise that Supreme Court case emphasized the importance of content neutrality. That is, your sign regulation shouldn't require you to look at what the sign says in order to make decisions about it. I think this ordinance achieves that. I think there are current provisions of our current code that do require you to assess the content of it, that it would give me pause, but I am not an attorney.
Thank you. With regards to the elimination of the 3 square foot wall signs on 1 and 2 family residential districts, I'm a little, I understand why you'd want to remove it, but I guess there's a concern that I have with regards to properties that are rented in the 1 and 2 family residential districts. With regards to, it takes sometimes when you have an issue with a property and it has a sign on it, and you have a landlord's contact information or a property manager's contact information to reach out to, could be helpful versus then just calling the city and having the city do the enforcement. I know property managers who are very responsive once they learn about issues, and I'm sure many of them would like to learn from the neighbors versus from the city when they're being fined or when other issues come up. So I'm not exactly on board for removing those signs. And that's the one sign that I'm thinking of right now, of having a property manager's contact information on a building so that the neighbors have some contact information. Was there a reason for the removal?
We had a similar discussion. Keep in mind that if it's provided, there's no restriction on content, so it could be property owner content, it could be some other message. We discussed it. I don't want to speak for everybody, but my rationale for it is that the character of those uses might be more prevalent in R1 and R2 districts. They tend to be more residential in nature. While some of them very much may be rental properties, the number of rental properties in the higher density areas are probably more prevalent. And so it was a balance of just what is the appropriate way to address character with permanent signs. But I think I would just, to link those two comments, I think that in balancing the opportunity for free speech, that unlimited temporary sign probably should be considered carefully if removed as it relates particularly to single and 1 and 2 family signage that don't have as many other opportunities for speech.
Okay. Is there any way to, I guess it's one of those things where I think for a lot of neighbors and for me personally, when I see a friend's sign attached to a building and I see that their lawn isn't cut, I make the phone call to the landlord or to my friend who has that property listed or is managing it. All of a sudden, this adds there's uncertainty just because if you go into the city records, you're not going to find out who the owner is if the property's managed by a management company. So I guess I'm just looking at it from just that angle of just knowing who the landlord is of the property. So but I understand what other message could go up there. Maybe I'm not thinking about that, and maybe that's, maybe we don't want that message up. So, depending on how we vote on this evening, if we table it, we might want to revisit that potentially. With regards to permits, so I did see that residential properties do not need a permit for temporary signs, but I did not see for commercial properties that are for lease. So the exceptions, no permit is required. It says temporary signs in residential zoning districts. And then the temporary freestanding signs permitted under section 5, all that in all zoning districts. I just want to clarify, does that mean there are no permits required for temporary signs in both residential and commercial districts? Is that correct?
I believe so, but let me double check. All temporary signs in residential zoning districts do not require a permit, and the unlimited sign in all districts don't require a permit. Other temporary signs in non-residential districts would require a permit.
So a commercial broker marketing a property for sale would be required to get a permit for a temporary sign?
Yes.
I think that's probably going to be an issue that we need to look at, just because there's a lot of commercial real estate in town and lots of signs, and currently permits are not required.
Again, though, we can't distinguish a for lease sign from other type of signage. So we could say that a potential amendment would be temporary signage in non-residential properties do not require a permit.
Mhm.
So that could be considered.
And I think that's the direction that I'd like to go in. And we can discuss that further. Then in regards to, I'm sorry, in my field of real estate, open house signs, are those considered temporary signs?
Probably.
Okay. So, whether they're put up for 2 hours or technically, open house signs don't go in front of a property that is for sale, other than one, but directional signs to the open house.
That would be a temporary sign that could potentially be within the required allotment of a residential property or running afoul of that, and could not be placed in the public right-of-way.
So a property that is, so I'm at the corner of Green and Plymouth, and I'm outside the right-of-way putting a directional sign on a property that I don't own. Is that an allowed use? Is that an allowed temporary sign?
It would be a freestanding sign, so long as they didn't already have the maximum number or square feet. And it would not require a permit, because it's likely in a residential area. If it were in a commercial area, and that was, currently, we would require a permit for a temporary sign.
Okay. So corner of Plymouth and Green is a commercial property, so in order for me to put a directional open house sign for 2 hours would require me to get a permit from the city.
Yes, technically, we can't regulate a sign for a specific duration differently.
And
I bet that happens.
And the current code, how does that, so I did see there was a provision for open house signs in the current code.
That is unfortunately content-specific, and the U.S. Supreme Court has said, shame on such language.
Okay. So that's another one. And then window signs, if we can go back to residential window signs. So in condominium complexes, some condominium complexes allow for property owners to put a for sale sign into a window. That's a temporary sign. Would that be considered a temporary sign?
Is it affixed to the window?
It is not well, it might be taped to the window.
Oh, you're killing me.
Leaning on the window?
Generally, we don't regulate residential windows through our sign ordinance now or as proposed. We do provide an additional freestanding sign, and that would be multiple family, which you'd be allowed a temporary wall sign up to 12 square feet. I think the ordinance is silent on it, so I think technically it would probably be illegal.
And that's a problem.
Well, then, so your goal would be to provide a specific allocation of residential window signage?
Temporary signage.
We have to look at creating, so right now we have two types of temporary signs, freestanding and wall. We could look at, I think we could look at how we would accommodate some use in that regard.
Okay.
I don't know exactly how that is.
Okay. And then I promise this is my last one, and I'm sorry. Alleys. So we've seen a little bit of, actually not in Ann Arbor quite yet, but I recently visited a business that's off of an alley here in town that does have signage on there. And, you know, we're starting to see in a lot of cities, major cities that have had really expensive real estate where alleys are being revitalized. Detroit is one of the places that we're seeing that. And I noticed that there's no more, you know, alleys are now looked upon as the building as a whole for signage. Was there a reason for getting away from allowing alley signage and making us part of separating it out, or no longer separating it out?
Yes, we determined that alley signs would be either wall signs, projecting signs, or could be potentially a canopy sign. It didn't need to be defined specifically. They're still permitted within those categories. You would have to choose to allocate your square footage to that face. Your square footage is still based on the building frontage, but we determined that it wasn't necessary to define it unto itself because an alley sign could probably more appropriately meet one of the forms of the types of signs we've defined.
Thank you. And just as a final thought, you know, with an item just brought up by Commissioner Briggs and some of the things that I've brought up, I think it might be worthwhile for us to table this for a little while, just to look at some of the issues that have been brought up and get additional community feedback on this before moving forward. But I will, of course, send this off to the commission to discuss. Commissioner Briggs.
Yes, I'm not sure if I was just not following the question properly or the answers properly, but I'm trying to make sure I'm understanding the temporary freestanding signs and your distinction between residential and commercial use. Because what I'm seeing is that there is an exception if the building or lot is for sale or lease, and that there are temporary signs that are permitted both in residential, multifamily, and non-residential. So I'm not understanding where a permit is required for a non-residential temporary real estate sign? I don't understand how that's, where is that?
Because we require permits for all signs except for those listed in section 5.29.2.
Yeah.
That reference there specifically addresses temporary signs in residential zoning districts, and the freestanding sign, that is the unlimited sign under the temporary freestanding sign. That could be amended to reference that section more generally to provide the exception from either the additional signage you get from building or lot for sale or unlimited sign. Again, keep in mind, though, that sub A is not a for lease sign. You get additional temporary freestanding sign for your property when it is for sale or for lease for that duration. It does not require you to use it for that purpose. We are content neutral on what you put on that sign.
That's additional to what's listed in this table.
Correct.
And so okay. I guess I don't know if I'm being obtuse on this or not. I just feel like I just don't understand why the non-residential isn't included. What exactly would need to be changed in this section?
So
To permit, to adjust for,
so that no temporary freestanding signs would require a permit?
right.
So the adjustment would be in 5.29.2, and it would, my initial thought it would read something that no permit is required for sub 3 temporary signs permitted under the temporary signs section. Under that circumstance, it would exempt temporary wall signs, freestanding signs, the exception signs from the the area and duration limitations. It would restrict any sign under that freestanding category from requiring a permit.
Okay, thank you. I was being obtuse, but I do now have it.
Commissioner Mills.
So, based on what you just said, now I understand the permit side, but on the exceptions for the temporary freestanding signs, I read that as exceptions from the time, how long, from the duration, not the amount of signage that you're allowed. Because I want to make sure that there is a limitation on the amount of for sale, for lease signage that's allowed. And I understand why we would want to exempt how long, if it takes more than 65 days to sell a property. I think that makes sense. But I just want to make sure that there are limitations on the amount of signage.
I think you're correct. I misspoke. I think that the exception in A provides you an exception from the duration of 65 days with a 30-day gap, so as long as that building or lot is for sale, it doesn't give you increased area. My apologies.
Okay, good. I think that it's really helpful just to make sure. And since we're on this section, I have the things, that's okay. I agree with, I agree with what Commissioner Briggs said about considering this like permanent temporary signage, like unlimited time for a temporary sign. The question that I have that actually maybe you can help us answer, I forgot your name, sorry. Is that it stipulates that it has to be a non-commercial message, which is interesting to me, given that we're moving towards content neutrality. So how does that work? Did that slip through the cracks, or was that intentional?
Yeah, without getting into this specific provision, the courts have left open the possibility to regulate commercial signage differently. Historically, commercial signage has been held to a lesser standard than non-commercial speech. So,
Okay, so if it is the way that I'm reading these now with these two exceptions next to each other, if a building owner is offering a building for lease, the first exception there, it falls within there, that they can, if it takes them 3 months to lease out or sell that building, they can have that temporary sign up for 3 months. And actually, that doesn't say whether it needs to be freestanding or it can be on a wall. Is that correct? Sorry, it doesn't have to be.
yeah, no, yeah, whatever temporary signage is allowed in that district.
Then you can have it freestanding
without
or on a
duration.
wall.
Yeah.
But in the case of what Commissioner Milstein was saying about wanting to have the phone number for whoever's managing the property, who also sends the message like, who you call if you want to lease the property, right? It's a year-round advertisement. Is that a gray area between what is commercial? I mean, in my mind, it's sort of commercial, right? But it could also serve a public safety or like a community standard. So like, I was reading this as the opportunity, that unlimited sign, the unlimited temporary sign, as the opportunity for the management company to put their 3 square foot sign up. But if it serves the purpose of like advertising how you can lease that property, that's commercial to me, isn't it?
Yeah, the determination of whether it's commercial or not would have to be made on a case-by-case basis by code enforcement staff.
Got it. And I think because of that, like, not knowing how that's gonna, I mean, unless staff knows how that's gonna pan out, because, I mean, we can look at some existing such signs, right? I think that this idea of being able to have signs that rotate, even if it's the same effective message, but that temporary sign can only be there for 2 months at a time, to keep it in good repair, in my mind, seems to make a whole lot more sense than to allow a freestanding sign, which we know has the opportunity to get ratty, right, to be there forever at an unlimited basis. So, and it resolves this whole, like, what is commercial and what is non-commercial business in my mind. That's my 2 cents worth on that. But I think that there's enough questions in here. I think what Commissioner Milstein said about when we require permits, requiring permits for real estate signs, or any temporary sign in that, for that matter, I think doesn't, I'm glad that you found that. Like, that seems super onerous in my mind.
Commissioner Sauvé?
So just on the permanent temporary sign, we do have a clause, though, that does say that it has to be placed in good repair as long as it's on display. So that would come down to enforcement, which actually gets back to the question of fines and enforcement. Like, fines are not in this. How are those updated or, modified, and like if enforcement isn't active enough to deter this, that people are gonna just put the signs back up again, what is the process of increasing fines or other forms of enforcement?
I believe the fines are in here.
Are they?
It's
Is
$500.
it just like another amendment that we?
Yeah, it's $500, section 5. $500 plus, and each day that a violation continues shall be deemed a separate violation.
So $500 a day. How often do we fine?
We have had, I don't know specifically. I can tell you our first approach is to try to get the property under compliance. Our typical process is when a violation is found, we will ideally reach out and seek voluntary compliance. That's sort of the most efficient use of everybody's resources to accomplish the goal of the ordinance. In the event that that doesn't do, we typically provide a notice of violation, which is a letter that we are going to communicate to the property owner that you are in violation of this specific provision. We'll provide some time period for correction. That often then achieves a lot more compliance beyond the voluntary. And then I don't have the exact numbers, but then the next step would be to issue a ticket. Sometimes that ticket issuance can result in compliance at that point. Sometimes we end up in court. And once we're in court, we're presenting our case that we believe it's a violation. They have the opportunity to dispute that. And at that point, it's kind of in the court's hands as to whether or not that's going to be upheld or not. In the event that it is, that gives us a lot more latitude then to ensure compliance is reached, or more confidence to start issuing more frequent tickets after that point. We're not typically in the process of issuing tickets after that notice of violation on a daily basis. We consider all of those to be deliberate, reasonable steps to try to bring the property into compliance.
Is the fining retroactive to the date of a notice, or is it
No,
in
each ticket
sequence?
would have to be issued on a daily basis in order to invoke that.
And Commissioner Survey, it reads not more than $500, not less
Right.
than $100.
It's usually 500.
So there's but that's a daily limit. So it can be $500 a day. It doesn't go $100 a day up to 5 days, and then they're capped out, sort of thing. It's interesting, to hear. It's things like even for the for sale and lease, if something's going up for lease fall 2020 right now, that's allowed to be up for a year, right? Which goes to, public comments about it, but regulating that content versus something else, we're trying to be flexible enough when we're talking about real estate a little bit differently within these residential temporary signs. But again, finding that balance. It's a hard one. I'm not envious, but I am trying to poke holes and play scenarios. But I also believe that we're probably planning for a lot of the worst case scenarios, that there is enforcement in place in a way, and that I don't know how many violations are going to come from open house or garage sale signs. And if they do start to come, then it's an amendment as an option to figure out how to manage that content. But, okay, thanks.
And just a clarification on the for lease signs for fall of 2020. This is the season when you see a lot of those signs. Rental season begins November 1st and runs through pretty much until August 2020. So it's not uncommon to see signs, although there are a lot of them out there right now. Further discussion? Commissioner Hammerschmidt.
I'm getting really nitpicky too with this temporary freestanding signs, but I just want to make sure. Okay, so in this exception, when the building is for sale, this is the maximum display period, blah, blah, blah. For temporary signs on that building or lot should be so the temporary signs, so you said you can have up to 4 temporary signs, right?
In residential.
In residential.
So for
and this-
temporary signs in non-residential, well, which are you asking about?
Well, the exceptions for temporary freestanding signs. I guess I'm not sure if this reads as if you have a home for lease in fall of 2020, can you have your 3 other temporary signs? It says, like, the fact that it says like temporary signs makes me concerned that since we're not regulating content, if you have a home for lease, in a year from now, could you have 3 other signs that just say whatever, and those are not regulated, and they can just be up until it's leased? Right. But we can't regulate content, so I don't know how to.
Yes.
Yes, we are providing an exception of timing for the temporary signs during that period that it's for sale or
The
lease.
temporary signs could say anything.
Correct,
If
correct.
okay. And these places are for lease pretty much always, it seems like.
November 1st is like a formal date of leasing.
Due to the city ordinance that requires the landlords not to start signing leases until 60 days after the beginning of the lease.
I mean, I don't know that anybody's gonna read the sign ordinance that closely, that all of these landlords all of a sudden are gonna be like, cool, I can just have like 4 temporary signs in my yard at all time because my house is always, but it gets back to the like clutter and blight issue that I'm sure residents in neighborhoods with a lot of rental properties are very concerned about, as I would be.
The message could, there are signs out there right now that say free heat, free Wi-Fi. So it doesn't necessarily say for lease.
Right.
It just has other messages on them.
And you can have up to 4 if the property is technically for lease.
It is, we could look at, if there was concern about that, is extending the prohibition on permanent signs further up on the number of units. That would decrease, you would still likely have the same temporary signage provisions, but you would have less total signage on the property through a combination of permanent and temporary signage.
Well, could you also just say that you're limited to 1 sign that's longer than 65 days, but any other temporary signs are still subject to, I mean, you're not regulating the content of that sign, but you're just allowing them one that's sort of until,
And we just have to presume which one they're designating.
it's their choice.
When no permits required.
Right.
It might be challenging.
So I think we have enough feedback at this point, or I think, Mr. Leonard, you have enough feedback at this point.
Well, I guess I'd appreciate a little bit more direction. So some of the questions that came up that I don't have a clear consensus if you'd like to see changed or what we can provide. One, I'm hearing some consensus on eliminating the requirements for permits for any temporary signs. I think. We can explore that. I heard 1, possibly 2 voices for regulating residential window signage.
So that we're not prohibiting it.
Right now, we're sort of quiet on it.
And being quiet on it,
So you would like to allow residential window signage throughout the city?
I would like that to count towards the signs that you're allowed. So whether it's, in my mind, whether it's window or wall, it's a building sign.
That'd be a temporary sign? Because then, for example, on single and two-family, we don't provide any permanent signage currently, although that's another question.
In my mind, putting it in a window has the same effect as putting it on a wall, in my mind.
Okay.
The permanency of it, I think, is a separate matter. Permanent window sign, permanent wall sign, or temporary, I don't want to add additional signage, but I think like the flexibility of putting it in a window, where putting it in a window rather than putting it on the wall is helpful.
So in a mixed-use building, well, let me think. A mixed-use building where you have retail and residential above, we only provide signage calculation to the ground floor. So in that circumstance, any window signage would have to be limited to a temporary status, or we would have to provide more signage allowed on that building.
Could the signage on the second floor be counted towards the maximum that's allowed?
Potentially, unless the first floor has already used up all the signage allocation, then there's none available. So that's what I'm just trying to.
I would be fine with that at that point, if they've used up all the maximum.
If the business frontage has used up the maximum for the building, none is available for upper stories.
Or the landlord or the building owner would then have to renegotiate shrinking the sign down on the first floor and.
Or how as written, is that situation handled? Can people upstairs put window signs in? Because if you just said that silence means
Not allowed.
not allowed, then it sounds to me like the status quo, leaving this as is.
You couldn't do that.
Those people upstairs could not put anything in their windows.
That's correct.
So in my mind, having collectively, right, not exceed the threshold that we put is a better situation than what we're currently in. There gives some upstairs some flexibility then.
Yeah, I think we're diving too deep. The intention and feedback I'm hearing is you want to provide the opportunity for residential window signage.
Yes. Not adding to sign plate, but replacing instead of wall.
And that will, okay.
Maybe Commissioner Sauvé disagrees.
Daylight versus covering the architecture. Part of my take, it feels temporary, like when we talk about what might be in an apartment window, would be the same thing a single-family residential might put in their yard. That it could, I know we're not talking about content, but it could be a political sign, or for sale sign, or for lease. So I would feel that in the window, because it's obstructing, feels like a temporary condition, where on a wall, affixed to kind of the wall outside of any residential use, feels more permanent, because it's not obstructing another feature in a way. And so if we're leaning towards allowing it, it feels like it actually falls more into the temporary than the permanent category. I don't know how that changes the area calculations and how that's vetted out, but that would be my leaning.
We'll look at options
Yep.
to allow it.
So that if I'm, like in a single-family use, when you've got 4 signs, if you put 3 in your yard and 1 in your window, they all just add up to the same thing. We're not adding more into it. It all feels temporary in my perspective. And then we're equally trying to approach all types of housing and residential uses in the same way, and not that dense housing has a permanent sort of requirement, where single-family and detached housing has a temporary
Well, it's still gonna have to,
allowability.
it's still gonna have to respond to the zoning districts where it's located. So, but we'll look how to
Yeah.
accomplish that in an equal manner.
Yeah, I think that's kind of my concern when we do talk about that use versus zoning. But we have to start somewhere, right? But the equity between who lives where, the typology of it.
I am hearing, consider removal of the exception for a single freestanding sign not subject to the time limitations. I just want to say that it is conceivable that when that comes back, my initial thought is that is, that's a bit of a accommodation from a absolute free speech opportunity for any property owner, but we'll look at it. And then the provision of a permanent sign for single and two-family residential. I heard a couple comments about that. I don't know if there's a unified vision. I wonder what you would like to see in regards to that.
I didn't hear, I think this is from Commissioner Hammerschmidt, and I didn't hear a single sign, like taking it from 4 to 1. I heard the exception of allowing only one of those signs to be up during the period of lease, not all 4, not all temporary signs.
I think, wait, is that what you're talking about, or you're talking about the sign on the, like a management company phone number?
I'm talking about
3
a
square
permanent
foot.
wall sign of up to 3 square feet on a 1 or 2 family residential.
Got it. Oh, sorry.
We did talk about that as well, though.
Yeah.
Is there any consensus on that?
Could we add and this is controlling what's on that sign, could we?
Then no.
What if it's contact information only, phone number only?
My initial reaction is that is restricting by content.
What if you lower it from 3 square feet to 1?
That could be accommodated.
If it's just for
1.5 square feet?
12 by 1 by 1?
So,
I mean, a
For a
sign
phone
that small,
number
I mean, you
and-
almost have to be on their property to read it.
or
2 square feet?
or
Yeah.
2 square
square
feet?
feet?
I think that would be but well, I would be in favor of eliminating, or of not eliminating signs. Whether it's 3 square feet, 1 square foot, or 2 square feet, doesn't really matter to me. Landlords will figure out a way to make it so they stand out, I'm assuming. So it's not going to be a white house with a white sign, for example. How about 1.5 feet? Commissioner Mills.
I would prefer that if we keep in the idea of this unlimited time, single sign, that I would prefer it in a window rather than freestanding, personally. I put that out there.
Wait, I thought we were talking about a wall,
Yeah.
wall signs.
Yeah.
We're talking about, we're
Sorry.
talking about, yeah, putting back in,
The wall
you know,
sign.
allowing a one
Yeah.
small permanent wall sign on 1 or 2 family residences.
Commissioner Sauvé?
I would say
Property
the circumstance, it's thinking about the circumstance that we set up to the content that might be provided, because we can't regulate content, so it's how do we create a circumstance that enables the content that we think is appropriate? And so a permanent wall sign of a certain scale of a house that's leased or rented, the lessee isn't going to affix a permanent sign to not their property. So allowing that permanent sign is probably going to be done by the management or the owner. And so the content is going to be something curated by the management or the owner. So I feel like that leads, towards the management number and contact information without actually trying to control what it is, right? If we do it with the temporary freestanding forever duration sign, that is a bit more muddy in terms of, like, a tenant could just put a sign out and let it sit out from November to August. So, and I think what it would do, if we reverted back to the wall sign, is it provides that permanent free speech opportunity. So if a tenant wanted to stick something on top of that contact information, they could, so that there is that permanent free speech ability on the wall instead of in the yard blight sort of scenario. So I think those two go hand in hand, that we trade off and find that balance and figure out how that scenario helps lead towards the content that we're looking for without curating the content. Brett, does that make sense? So basically, I think I'm going towards the wall sign because it allows us to redact the temporary permanent freestanding sign
Possibly.
and enable permanent free speech, but in a circumstance where people are leasing it, it's probably going to be the management or the owner that is going to put the content on that.
Or can you, if we kept the temporary, unlimited, whatever, can you limit the permanent wall signs to just properties for rent? Because that's not regulating content. Or is that not
My
constitutional?
initial reaction is I don't like the distinction of changing regulations based on the occupancy tenure. A single-family owner and a single-family rental property should be considered, I think, the same in regulations. It is considered differently through other building code requirements, but my initial reaction is that's probably difficult from a zoning perspective.
Commissioner Briggs.
Since this is getting tabled, it appears, this is one area that I would love to hear some feedback from neighborhood associations in terms of what they would like to see. I would defer a lot on the wall sign piece on that in terms of whether or not they would feel that having that contact information would continue to be useful. But I do like the idea that it's going to be maintained, that it's a smaller size. Personally, I liked the removal of the wall signs, but I could be persuaded if it felt like something that's actually benefiting neighborhoods and folks that are living there regularly that are addressing these issues. With regards to the unlimited sign, just to throw one other piece, I know your concern is around free speech. To me, it seems that we are favoring free speech for those folks who have a yard and have the ability to put up a freestanding sign. So I think we are providing greater speech for certain types of individuals in our community. And so I'd be curious to see, as you guys are discussing this after this meeting, how that plays out. But I'm not persuaded necessarily that we're offering more, but I'm not a lawyer, so.
So the point would be that if provided, it should be one temporary sign, not one temporary freestanding sign.
Mm-hmm.
Though personally, I don't think we need unlimited signs, but.
And then open house signs, garage sale signs.
No.
Feels a little more neutral.
Yeah, a garage sale sign, or an estate sale, or something along those lines. If we could, have some,
Leeway.
text about that for us to read, that'd be great.
So you would be interested in some exception that says you can do any temporary sign at any location so long as it's not present for more than 4 hours?
Or 8.
I'm a soft no on that, but we can look at it.
That's all I ask.
Okay, so my to-do is look at eliminating the requirement for permits for all temporary sign permits. Look at the potential regulation or provision of residential window signs, perhaps as a temporary option. Evaluate the unlimited temporary freestanding sign. Could it be eliminated? If kept, could it be generalized to provide more choice as to how it's realized as a temporary sign instead of just freestanding? Is there any specific provision for temporary time-limited signs and potentially adding back in single and two-family 3-square-foot sign, and specifically trying to solicit feedback from the community about that particular issue? Does that seem like the list?
Is my thing about if your property is for lease, can you really have
One sign or
4?
all signs?
Yeah.
Commissioner Woods.
Yeah, so that last part you said, that's about those small signs that go on houses sometimes that have the information. It seems like with technology, and just anecdotally from a lot of my students, it seems like people do a lot more online and going to, I don't even know the names of the apps, but to find out where property and things like that are available as opposed to looking at those signs. So hopefully eventually we're sort of getting away from those, even though I know, no, we're not. Well, we should, because I think it's just adding to what some people are feeling is not the best look for the neighborhoods. So just wanted to put that in there. Okay, all right. I would be interested in knowing what % of your sales are actually from the online kinds of, realty programs as opposed to people just driving down the street and seeing it on a house.
Don't get them started.
Okay, never mind. Well, you can tell us later.
Here's the only, I will mention this, the reason why I like for sale signs is when I'm driving through a neighborhood and I'm going to show a house, I don't have to look at the street numbers. I just see the for sale sign, and I know I need to pull in that driveway. And in some neighborhoods that have a lot of cookie cutter homes, it's very helpful to have that sign there. But that's as a real estate agent, that's why I like for sale signs.
Okay, and so you don't use GPS and all that stuff?
It says you're here and you're looking around and you're like, no, I'm not anywhere near here.
All right, that's enough of a commercial break, then we'll get back to.
All right, Mr. Leonard, do we have enough to take a motion, or do you have enough feedback so that we could table this?
Yes, my tabling would allow us to bring it back when we feel like we've addressed all the questions, given the opportunity for some additional feedback. My initial thought is that I might shoot for the second January or the first February meeting.
All right, do I have a motion to table? Moved by Commissioner Mills, seconded by Commissioner Woods. Any discussion on tabling? All those in favor, please say aye.
Aye.
Opposed? All right, we are tabled. Next item on our agenda is 2260 Traver Road Annexation and Zoning for City Council approval. Mr. Leonard, Mr. Chang will deliver staff report.
Okay. The petitioner is located on the east side of Traver Road, south of Traver Boulevard. They are in Ann Arbor Township. They're requesting to annex 3.5 acres and rezoning to R1B, which is single-family residential. The owner is requesting sanitary sewer service from the city since their septic system is failing. Staff recommends approval. I'm here for any comments you may have.
All right, at this time, I'd like to open up the public hearing. If there's anybody in the audience who wishes to address the Planning Commission in regards to this item, please step up to the podium, state your name and address for the record, and you'll have up to 3 minutes to address the Planning Commission in regards to this item. Seeing nobody, I will close the public hearing and I will read the motion. The Ann Arbor City Planning Commission hereby recommends that the mayor and city council approve the Hosford annexation and R1B single-family dwelling district zoning 2260 Traver Road. Moved by Commissioner Sauvé, seconded by Commissioner Mills. Do we have discussion? Seeing none, all those in favor, please say aye.
Aye.
Opposed? It is approved. Welcome to the city of Ann Arbor. All right, moving on to audience participation. At this time, any members of the audience may address the Planning Commission. If there are members of the audience, you have up to 3 minutes to address the Planning Commission. Please state your name and address for the record.
Jeff Crockett, 506 East Kingsley, and this evening I'm a happy guy. I appreciate, and this is why they pay you the big bucks, to look at all, this is really complicated stuff, you know, so I am very grateful. I just, if you want citizen input, you know, give us a call. We'd be happy to come in and talk. I appreciate, Erica, you making that comment. I would just like to say that I think we can do better in enforcement than the current plan in place. I mean, there are things, I was just thinking the other day, why is the burden on the neighborhoods? Why couldn't, for example, a person who puts up a sign simply take a picture of the sign? Because if you take a picture on the sign of your cell phone, you got a date. So you have some kind of evidence of what you've done. So it would be the obligation of the person who sets up a temporary sign to take a picture of it, to date it. And if you're a commercial enterprise, it would seem to me that you report it so that you have some proof. So in other words, if you don't have that proof, and it's driven by complaint, but guess who does the complaining? People who are sort of walk around sort of like us. So we make a complaint, there's an investigation, but there's no proof of when the sign comes up. So the proof is the complaint. So it could be 30 days, 45 days when we're walking around and notice this house, we make a call, and the 60-day limit starts from the day that you make the complaint. Something's not right with that. The other thing that could be done that would be simple, I mean, you can create online survey where someone who sets up a sign goes and just simply enters when they put up the sign on the location. Doesn't cost anything. but it'd be some way to record it. So I guess what I'm asking is, in terms of enforcement, that you at least have the conversation to think, is there a way, that we can sort of do it better? So I would encourage that. And the last thing I wanted to say is I'm hoping that part of the consideration is timing, so that neighborhoods and neighborhood groups have an opportunity to review an ordinance. Because the way it's set up right now, I mean, when we find out about it on a Friday, we don't have, the staff here is over the weekend, so we send in feedback on Monday. There's just no time. Something's not right with that. I know at City Council, I think they're moving toward, at least a week between the time that a staff report comes in and when there's feedback. That, to me, is a little more reasonable. So I would urge you, basically to think about creatively about enforcement and then in terms of the timing. Thank you very much.
Thank you. Is there anyone else in the audience who wishes to address the Planning Commission? Seeing no one, any commission proposed business? Commissioner Mills?
I am sad that Mr. Garber left because I think what he had to say fits nicely to what we were talking about before for planned projects. I hope that, Mr. Leonard, you could add to the list of potential things to add to the planned projects, electrification, like not including natural gas hookups. That's something that we can definitely treat as a public benefit, I think, now, regardless of how they sort out whether, how banning a natural gas connection fits with either the building code or the energy code. And if Mr. Garber is listening, that's something that I think other cities are interested in too. So I've got a group digging into that as well. I think, so both that and kind of beefing up what we require, or what we're requiring in terms of renewable energy through that planned project process, I think are two of the key things that I would like to see that mesh with other goals that we have identified. I think that it might be wise to look at that soon, so I'm not sure when we can schedule that. But now that it's come up in a couple different occasions, and we've said it for a couple of years too.
Further commission proposed business? All right. So as we're winding down our year, I hope everyone has a happy holiday, whether you're here on the commission or the audience, or anybody watching at home. Have a great holiday and a happy new year. And I will take a motion to adjourn. Moved by Commissioner Abrams, seconded by Commissioner Mills. We are adjourned. Thank you.